Hi, very good morning. Uh, this is a case under arbitration and also under Constitution of India. Very, very important case, rarest of rare case. That is why I want to share this case with you. The citation is Delhi Metro Rail Corporation Limited versus Delhi Airport Metro Express Private Limited. I will call Delhi Metro Railway Corporation as DMRL, um, DMRC, and the Delhi Airport Metro Express Private Limited as DAMEPL. 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 DMRC, first facts. Without facts, law will not be clear. Too much of facts, you will not be interested in hearing. Instead, you can read the judgment also. So, I will give you briefly the facts and briefly the law. It is only to keep in mind what is the law laid down by the Supreme Court. That is the important crux of all my postings. DMRC is wholly owned by Government of India and National Capital Territory of Delhi. DAMEPL, that is DAMEPL. It is a consortium comprising of Reliance Infrastructure and a Spanish company. Don't worry about the name. It is a Spanish company. The consortium backed a contract for construction, operation, and maintenance of metro rail connectivity between New Delhi railway station and Indira Gandhi International Airport. Under the agreement, DAMEPL was granted exclusive rights to manage the project as a commercial enterprise. DAMEPL, after some time, expressed its intention to stop its operations, alleging that the line was unsafe to operate, not safe for the public. After 1 year of operation, they said this. Operations were actually stopped in July 2012. DAMEPL issued a notice to DMRL listing what are all the defects. 1, 2, 3, 4, 5. They have listed the defects. Notice stated that the defects were attributable to faulty construction and design. They requested DMRL to rectify the defects within 90 days. That is the why 90 days we will see later. Otherwise, they will consider it as a material defect and terminate the agreement. Finally, DAMEPL terminated the agreement on the ground that defects were not rectified within 90 days. They terminated the agreement. Then they made a joint application to Commissioner of Metro Safety in between. Commissioner of Metro Safety, after inspection, allowed operations on certain conditions. Some speed restrictions he put and then he allowed the operations. Based on that, operations were again commenced by DAMEPL. Then slowly DAMEPL started withdrawing. They handed over the assets to DMRC. After that, DMRC continued the metro rail operations. DMRC initiated arbitration proceedings after the conciliation attempts failed. They tried to reconcile, but DMPL said nothing doing, finish, terminated. So DMRC initiated arbitration. The arbitral tribunal was a unanimous award in favor of DMPL. The tribunal awarded approximately rupees 3,000 crores plus interest to DMPL. Then DMRC, they filed an application under section 34 before the Delhi High Court, which was dismissed by a single bench. DMRC filed appeal before the division bench. Then the appeal was partly allowed. Against that decision, DMPL filed a special leave petition before the Supreme Court. Supreme Court allowed the appeal, special leave petition of DMPL. It restored the order of the tribunal, arbitral tribunal. Then DMRC filed a review petition against that judgment. That was dismissed. After the dismissal of the review petition, see, this is the point. A curative petition was filed before Supreme Court. SLP getting admission Whoever is appearing in Supreme Court, they will know. Getting admission in SLP, that itself is extremely difficult. After your SLP is admitted, heard, and then a decision is made, filing a review petition, mostly 99% it will be dismissed because it is with a limited scope for reviewing the order. Then after that review petition is also dismissed, filing a curative petition and then it is getting admitted. That itself is it's a rarest of rare case. That is why I am giving this case to you. Then Supreme Court says about the curative jurisdiction of Supreme Court. The court relied on a constitutional bench judgment which said the duty to do justice in this rarest of rare cases shall have to prevail over the policy of certainty of judgment, as though it is essentially in the public interest that a final judgment of the final court in the country should not be open to challenge. Yet, there may be circumstances wherein declining to reconsider the judgment would be oppressive to judicial conscience and would cause perpetuation of irremediable justice. Normally, why the Supreme Court is not interfering? It is because of the public policy. Judgment should have the finality, otherwise, everybody will be challenging it. So, normally, if a judgment is given, then it will not be open to challenge. But Supreme Court says there may be circumstances wherein if the Supreme Court itself, if it declines to consider the judgment, then it will be oppressive to judicial conscience. That is what it says. The court laid down the principle that curative petition can be entertained, one, to prevent abuse of process, two, to cure a gross miscarriage of justice. Examples also they have given. One is violation of principles of natural justice. I think this is holding the field for several decades. One. Two is judge fails to disclose his connection with the subject matter or parties. The court said it is neither permissible nor possible to enumerate all the grounds on which such a petition may be entertained. It is difficult. Almost this is also said in every case. A further procedural requirement is a certificate from a senior advocate. So, if you want to file a curative petition, then a certificate from the senior advocate that this case is fit for consideration by Supreme Court is also necessary. That is the procedural requirement. Then the Supreme Court examined the facts of the case and it says what is patent illegality. So, that is one of the reasons in which the court can interfere with the award of the arbitral tribunal. The court then considered on what grounds a court can interfere with arbitral awards. The court said patent illegality is available for setting aside a domestic award. If the decision of the arbitrator is found to be perverse, that is point number one. Two, so irrational that no reasonable person would have arrived at it. Three, construction of the contract is such that no fair or reasonable person would take that view. Four, the view of the arbitrator is not even a possible view. These are all patent illegalities. A finding, then the court adds on, a finding based on no evidence at all, or an award which ignores vital evidence in arriving at its decision would be perverse and liable to be set aside under the head of patent illegality. An award without reasons would suffer from patent illegality. The arbitrator commits a patent illegality by deciding a matter not within his jurisdiction or violating a fundamental principle of natural justice. So, what is patent illegality has been broadly given by Supreme Court. Then the Supreme Court said that interpretation of contract cannot be unreasonable such that no person of ordinary prudence would take it. Contract should be given full effect. Then it gets into the case. In the present case, DMRC versus Dame Pill, Supreme Court looked at the contract especially the termination clause. This is very interesting. The contract, especially the termination clause, used two terms. Please note, one is cure and the other is effective steps to cure the defect. One is curing the defect, another is effective steps to curing the defect. The relevant clause said, I am quoting that clause, half of it I am quoting. If DMRC failed to cure or take effective steps for curing such breach within 90 days of receipt of notice. That is what I said. 90 days. Why that? What is the sanctity of 90 days? I will tell you later. That is what the clause says. So here they have used two words. If DMRC failed to cure or take effective steps to cure the defect within 90 days of receipt of notice. Let us not bother about the balance clause. Supreme Court, after analyzing the facts, noted that some defects pointed out by Dame were cured and effective steps were taken by DMRC to cure the balance defects. After inspection of an independent engineer, there was no concern for public safety. Trials conducted at full speed were successful on the rail track. The metro trains were run and they found the tracks were safe. CMRS certificate regarding the safety was overlooked by the tribunal, which is a vital piece of evidence about the safety of passengers. The notice issued for termination places reliance on the safety of passengers, and this issue falls directly within the domain of CMRS. The termination notice was issued by Dame saying that the line is not safe for the passengers. But who is the authority for certifying it? It is the CMRS, that is the Commissioner of Metro Safety. He has given the certificate. This has been overlooked by the tribunal. The cure notice, that is the notice given by the Dame contained allegations that the line was not operational. But evidence on record indicated the line was fully operational. The Supreme Court said, even if we accept that the finding of the tribunal that defects were not completely cured, DMRC took effective steps for curing the defects, which led to resumption of operation. So the award said, no, DMRC, you have not rectified the defects. You have not cured the defects. On that basis, they awarded 3,000 crores to Dame. Within 90 days, you have not rectified the defects. So I am giving 3,000 crores to Dame. Now Supreme Court says, no, the clause contains not only curing the defect, but effective steps for curing the defect. DMRC not only cured the defects, but also took effective steps for curing the defects, which led to resumption of operation. The award contains no reason why steps taken by DMRC were not effective steps within the meaning of termination clause. Supreme Court said the award is unreasoned, overlooked vital evidence. That is that Commissioner of Railway Safety who issued the certificate that the metro trains can be run on the track. It ensures public safety. That has been ignored. Ignore the terms of the termination clause because termination clause contained curing the defect and also effective steps for curing the defect. In any case, according to Supreme Court, the DMRC has taken effective steps to cure the defects. The conclusion reached by the tribunal is not possible for any reasonable body of persons to arrive at. The tribunal rejected erroneously the CMRS certificate, failed to reconcile inconsistencies between factual amendments made in the cure notice and the evidence of successful running of line. They failed to notice that. Even Supreme Court did not notice that. That is the point. Supreme Court allowed the curative petition. It set aside the arbitral award. Then it directed the Dame to refund the money which it has taken from DMRC to it. That also it directed. My comments are, DMRC's one of the submission was that termination notice was issued for a they have for a different reason. That is, Dempel found that the project was not financially viable. That is the real reason. But they said, no, no, the track is not safe for the passengers, etc. And on that ground, they wanted to terminate. The real reason is financially the project was not working. That is the real reason. But unfortunately for Dempel, a jackpot, that is rupees 3,000 crores, which it would have got because even the review petition got dismissed, was lost. This is the beauty of this judgment. Thank you very much. Have a great and wonderful day. Bye.